In May 2025, the Oregon Department of Environmental Quality issued an official memo exercising enforcement discretion for the Advanced Clean Trucks regulation, covering all Class 2B through Class 8 vehicles for model years 2025 and 2026. In plain language, Oregon's own regulators admitted they could not enforce the California truck mandate they had adopted for their own state. The trucks their dealers needed to sell were not available in the numbers California's regulation required. A state had legally bound itself to a California rule that was strangling its own truck market. And Oregon was not alone. Vermont Governor Phil Scott issued Executive Order 0425 in May 2025, pausing enforcement of electric vehicle sales mandates through December 31, 2026, citing charging infrastructure limitations and the technological unreadiness of zero-emission trucks. A governor pausing his own state's electric vehicle mandate. He acted because the mandate was breaking his state's truck supply. This is not a future scenario. This is what happened in 2025. What is happening in federal courtrooms right now, in 2026, determines whether it gets worse. Much worse. Today we are going to show you the legal battle that is deciding the future of your truck right now, the specific laws, the specific cases, the specific states, and what smart owners are doing before a single ruling changes everything. Here is what you need to understand about Section 177 of the Clean Air Act. Under Section 177, any state in America can adopt California's vehicle emission standards instead of the weaker federal standard. Not their own standards, California's exact standards. In a speech on the House floor in 2025, Congressman Morgan Griffith of Virginia explained it directly. He said the following: "What makes these California rules have such an outsized impact on the rest of the country is that under Section 177 of the Clean Air Act, other states can opt into the California standard. Not only does California dominate because of its sheer size, but when a handful of other states opt in, the California standard becomes the de facto national standard for the United States." He is right. And that is exactly what happened. Before the June 2025 Congressional Review Act resolutions, California's Advanced Clean Cars 2 program required that 35% of all new passenger cars and light trucks sold in California, beginning with model year 2026, be zero-emission vehicles. By 2035, that number was 100%. Connecticut, Maine, Maryland, Massachusetts, New Jersey, New York, Oregon, Pennsylvania, Rhode Island, Vermont, and Washington had all adopted California's authority. 11 states, covering roughly 30% of the American vehicle market. Every one of them was legally bound to California's 2026 model year zero-emission vehicle quota. The Auto Innovators Trade Group, which represents Ford, GM, Toyota, Stellantis, and Volkswagen, published an internal memo in December 2024 warning that achieving California's zero-emission vehicle sales targets would take a miracle. Their words, not ours, a miracle. In June 2025, President Trump signed 3 Congressional Review Act resolutions that revoked California's federal waiver for ACC2, the Advanced Clean Trucks mandate, and the heavy-duty NOx regulation. Gina Jones is a professional truck driver who stood at the lectern at the White House signing ceremony. She said that we cannot allow one state's regulations to disrupt our entire nation's supply chain. Todd Spencer, president of the Owner-Operator Independent Drivers Association, which represents 150,000 small business truck operators, said that electric trucks are not a realistic option right now. He said they are too expensive, the charging infrastructure is not there, and California's rules are already driving up the cost of doing business. The trucking industry celebrated. Mechanics celebrated. Every owner of a gas-powered truck in America had reason to believe the worst was over. And then, California filed suit. Within days of the signing, California and 10 other states filed in federal court, arguing that Congressional Review Act resolutions cannot legally revoke Clean Air Act waivers. Both the Government Accountability Office and the Senate Parliamentarian had already issued opinions supporting California's legal position. The GAO stated that California's waivers are not rules for Congressional Review Act purposes. The Senate Parliamentarian reaffirmed that finding in April 2025. If a federal court agrees, all 3 of Trump's signed resolutions are nullified. California's ACC2 gas car mandate comes back into force. Not gradually, not with a transition period, immediately. On the day of the ruling and retroactive to model year 2026 vehicles. That case is in active litigation right now. You might think this only affects new car sales. It does not. When new gas truck supply is restricted in a state, the U.S. market tightens immediately. Prices rise. Parts stocking models shift. Independent shops that specialize in combustion engines lose the volume that keeps them economically viable. New York alone was projected to fall 176,000 vehicles short of the 35% zero-emission vehicle requirement in model year 2026 under California's math. When an automaker faces that kind of shortfall, one documented response is to reduce gas vehicle allocations to those states entirely. Not as a legal requirement, as a business decision. Fewer new gas trucks shipped to a state means fewer trade-ins on dealer lots, fewer parts orders placed with distributors, and fewer technicians trained on platforms that are disappearing from the new car floor. Your 2005 F-150 does not get pulled from your driveway, but the ecosystem it depends on slowly starves around it. And there is a second front in this war that almost no one is covering. In April 2026, the Department of Justice filed a separate lawsuit against California's Air Resources Board, seeking to overturn CARB's remaining tailpipe carbon dioxide standards under its older ACC1 program. The June 2025 resolutions did not touch ACC1. CARB still retains legal authority under the older mandate. California Governor Newsom signed an executive order in June 2025, directing CARB to develop new zero-emission vehicle regulations designed to accomplish the same outcome as ACC2 through a legal pathway immune to the Congressional Review Act. The new regulations are being drafted right now. The legal war is not over. You might think California lost. California reloaded. The 12 states that bound themselves to California's authority are Connecticut, Maine, Maryland, Massachusetts, New Jersey, New York, Oregon, Pennsylvania, Rhode Island, Vermont, and Washington. If you own a truck and you live in any of those states, the outcome of California's federal lawsuit is the most important automotive regulatory event of the next 12 months. One federal court injunction restoring ACC2 while the case proceeds returns the mandate to all 11 states overnight. Without a vote, without a public comment period, without 24 hours of warning. One judge, one order. 12 states, overnight. Smart owners in these states are acting now. They are buying trucks made before 2015 while the new truck ecosystem in their state is still intact, and used prices have not absorbed the full impact of potential supply restriction. They are registering trucks as work vehicles or farm vehicles where state exemptions exist, creating a documented legal pathway that survives regardless of how the mandate litigation resolves. And they are paying attention to this case. The dealers are not warning them. The mainstream press is not covering it. The information is here. One ruling is sitting in a federal courthouse. If it goes the wrong way, the used truck market in 12 states gets choked from the top of the supply chain down. Parts follow sales. Infrastructure follows parts. The ecosystem your old truck lives inside starts collapsing the day the ink dries. Are you in one of the 12 Section 177 states? Are you tracking California versus the United States litigation? Sound off in the comments below. The community here is the only place this is being discussed seriously. If you refuse to let one federal court ruling determine whether your truck survives in your state, hit the subscribe button and join the resistance. Keep the old iron running. Keep turning your own wrenches, and we will see you in the next one.